Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News. I've got a wild video for you regarding the Clayton Echard paternity scandal that has been rocking Bachelor Nation. Now, I don't normally employ the technique of hyperbole when I share content. I'll let you guys decide, but it is my belief that I'm about to read for you some court papers, some documents here, that are going to absolutely drop your jaw. Before you watch this video, get a sling around your jaw to prevent it from hitting the floor. It's absolutely crazy. So crazy, Clayton saves his case. That's right. I've got this photo here of Clayton as a lifeguard. You might remember him as the star of The Bachelor. And it would be so dumb of me if I was like going to pretend he was on Life, what's it called again? Baywatch, and I play this stupid music. Come on, we wouldn't do something so juvenile. But here it is. Clayton Echard saving his case. In this video, I'm going to share with you the 59-page court document here. Clayton Echard, the Baywatch Bachelor. All right, folks. And look, I mean, hey, the lyrics for this song are pretty money, you know what I mean? He needed someone to stand up in the darkness. It's going to be so all right. I won't let you out of my sight as we cover this case right now. Now, I've redacted the names of the petitioner here because I don't want to embarrass her. It's about Clayton's truth. And, she's losing, as it appears in my eyes, this court case. But you never know. The judge could dismiss it at any time. They have filed a motion to expedite the dismissal to say, we don't want this court case to go on. We're no longer pregnant. Nothing to see here. And of course, Clayton is saying, actually, I want to save the hell out of this thing because I want to prove that I am not the father of these unborn twins, or the no longer unborn twins here. So either way, the matter itself is serious and seriously sad, to be honest. Here's a response objection to petitioner, that's Jane Doe's, motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice. So if you haven't been following it, Jane Doe essentially says, since I'm no longer pregnant, we no longer need to be in family court, move on with the story. Clayton says, oh, no. You don't get to just walk away from this shit you took in my living room. That's what he's saying. You need to go get the wet wipes. Okay, and I'm going to read this full thing for you. 59 pages, but probably 30 of those pages are things we've already covered, so we're going to go through. What I'm going to share with you at the end here, the final two emails I'm going to share with you are going to blow your mind. Clear your schedule. Maybe you were going to propose to your loved one today. Push it off till tomorrow. Oh, you got a cracked tooth that's causing you mind-numbing pain. We'll get to it later. Oh, your taxes are late. The IRS is at your door. Explain to them the gravity of this situation. We'll reschedule. Let's do this. Respondent Clayton Echard, by and through undersigned counsel, hereby responds and objects, Your Honor, to petitioner's motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice. And that means, she wants it with prejudice, like we'll never see this again, case closed. And he's saying, no. Petitioner, Jane Doe's motion, must be denied. As a motion alleging, without any proof that petitioner was pregnant in the first place, that petitioner is now without child is insufficient cause for a dismissal under Rule 29A1. Permitting petitioner to bring this action, seek out media attention, force respondent into court to respond to baseless and malicious allegations in 3 different court cases before 3 different Maricopa County Superior Court judges, to then absolve herself by suddenly claiming without any evidence that she is not pregnant would be a gross miscarriage of justice.
Garbage.
Petitioner continues to demonstrate that she is eager to utilize the media to support her fabricated pregnancy narrative, and she will continue to claim that she was pregnant by respondent unless this court adjudicates this matter with a finding of non-paternity. On or about January 2nd, 2024, petitioner again contacted The Sun and stated she firmly stands by everything, and she had a positive pregnancy test at one point that confirmed her pregnancy. The current existence of her pregnancy, as explained below, is insufficient cause for a dismissal. An adjudication that she was never pregnant, or at least that she was never pregnant by respondent, is what justice requires. So she's trying to play both sides, petitioner, right? She's trying to tell the media, I was pregnant at one time, but in this court, she was saying I was really pregnant. I had a bump. I had 24 weeks. I was already breastfeeding. She was, I made the last part up. She was going hard saying, so you can't have both. You can't have both. Either you were pregnant up until 24 weeks, like you said, or past that, or you just had a pregnancy test that was confirmed, 7 months ago, which again, people have said you could literally spill some of your apple juice on that. You're drinking a Capri Sun, it leaks out. Next thing you know, you're pregnant. Come on. Dangerous world out there. To the extent applicable, respondents pending motion for leave to amend respondents' response to petition to establish paternity, notice of filing, affidavit of non-paternity, and expedited motion to extend dismissal date on inactive calendar together pending pleadings are incorporated herein by reference. Okay, that's a lot of illegal information we didn't need to hear. Petitioner's motion, again, to just button things up. And again, don't forget, there is a deposition scheduled on January 17th. They want this to go away before the deposition of Jane Doe. And we, of course, are saying, let's clog this system up a little bit longer till we get her on record for probably 2 hours stating her case so we can poke holes in it like a Swiss cheese, the fromage de Suisse. Is that how I say it? Okay, petitioner's motion, as well as other petitions filings in this matter, lacks evidentiary support, misstates well-established Arizona law and policy surrounding subject matter jurisdiction, and would deprive respondent of basic access to justice after he was involuntarily dragged into court to defend himself. Put plainly, petitioner's motion cannot be granted, and to do so would be to commit grave and clear error. As and for his response objection, respondent provides as follows. Yeah, this is legal talk for them saying, Judge, come on, don't do this. A motion stating that petitioner is no longer pregnant creates evidentiary issues that must be resolved by this court. So here are the respondents' objections. After repeatedly claiming and insisting that she was 100% pregnant by respondent in filings, under oath, in various court hearings, and in hundreds of social media posts, petitioner cannot be permitted to suddenly claim without any evidence that she is no longer pregnant. Critically, petitioner stated under oath and without any medical evidence that she was 24 weeks pregnant, due on February 4th, 2024, as of November 2nd, 2023. Petitioner also appeared in court before Judge Geltketsis via video on October 24th with what appeared to be a pregnant stomach, which upon information and belief was actually a moon bump or a fake stomach to appear pregnant. At this time, petitioner also requested judge permit her to show the respondent her stomach to verify she was pregnant, which judge denied. So there she was with what Clayton's lawyer is accusing her to have, which is a prosthetic stomach, a faux bump, as it were. The old post-Thanksgiving pudge, they call it. If petitioner is now alleging that she is no longer pregnant because of a miscarriage, a third trimester abortion, or whatever she is claiming, her motion to dismiss curiously lacks any explanation. She must provide documentation to support the same. That's true. Her motion to dismiss doesn't say anything other than she's no longer pregnant. I mean, what, was she giving birth to vague babies here? Because she's got plenty of those. She's pregnant with vagueness. Oh, what's your baby's name? Vague. This is a vague baby. Miscarriage this late in an alleged pregnancy would require medical attention, if not full hospitalization, and there would be a fetal death certificates filed with vital records consistent with this code. A death certificate to be filed within 7 days of fetal death where the fetus is past 20 weeks or 350 grams in weight. So maybe she'll claim they were under 350 grams. I don't know. Maybe they were 0 grams because they didn't exist. They weigh as much as my imagination could imagine. If she otherwise disposed of the twin fetuses, a criminal investigation would be warranted to locate the remains. Petitioner must provide respondent and this court with evidence to support the existence and now non-existence of a pregnancy. I want to remind you guys, I'm still being sued for harassment by her. If you think that's bogus, join us on the Patreon, patreon.com/Dave Neal. We're raising funds to continue to fight this case. Clayton has taught me a good lesson here, which is you need a good lawyer. Even if you're innocent, you need a good lawyer. And I tell you what, a solidly positive Yelp review is in the works for his lawyers over here. Holy cow. Wow. Petitioner's ability to provide this evidence or any evidence that complies with Rule 2 is highly dubious, and any testimony she provides should be carefully assessed, as petitioner is entirely lacking in credibility. As outlined in respondent's pending pleadings, petitioner has provided no verifiable medical evidence to support her claim that she was ever pregnant. Instead, petitioner offered unverifiable screenshots of appointments, positive HCG tests, a sonogram video taken from a 7-year-old YouTube video, credit to the flock on that one, and a demonstratively fabricated sonogram. Out of 3 fetal DNA tests, 2 have come back showing little to no fetal DNA. 1 was allegedly lost in transit. A conclusive paternity determination has now been made impossible as petitioner refused to comply with the 4th test and ostensibly has determined that stating she is no longer pregnant will allow her to evade the paternity issue and continue to perpetuate the false narrative that she was pregnant by respondent. Boy, did they give you, when you go to law school, did they give you like a law thesaurus so you know how to use the right words? I mean, perpetuate. I mean, come on, Isabel and Woodnick Law over here are just a who's who of legal terms, just slamming a metaphorical snowball fight, just one after another, shot after shot. No wonder after these filings, Jane Doe's lawyer was like, you know what? I'm actually busy on that day. I got a student fair project I got to help my son with. You know, science fair is kind of a big deal in my family. You know, we got volcanoes to make. We're going to be fertilizing some plants. I just don't have the time. I got to go. Bye. Have fun. The court must be provided with concrete and verifiable evidence to establish this critical fact that petitioner was pregnant by respondent and is no longer pregnant with respondent's twins to determine whether there is cause to go forward. Speaking about science fairs, imagine taking this case up. If you had a blowjob by a man, or if a lady gave you a blowjob and she then claimed, you know, it's like, all right, I'd be at that blowjob, I'd be at that science fair project. You got a grade A for a BJ. Might be the best video we've ever made. Without belaboring the point, petitioner has not provided any Rule 49 disclosure, any verified sonogram reports, any fetal anatomy scans, any sonograms from weekly checkups, any documentation to support her statement under oath that she was 24 weeks pregnant on November 2nd, 2023, or any medical records supporting the existence of pregnancy at all. She refuses to sign a simple HIPAA form to permit the release of records from the various medical professionals that she claimed under oath that she was being seen by for her high-risk pregnancy. She now seeks to have the actions she filed dismissed by claiming that she is no longer pregnant, still without providing any evidence to support the same. This cannot be permitted. To properly resolve this action, petitioner must prove with evidence in compliance with Rule 2 that petitioner curiously invoked, despite never providing any verifiable evidence to any court, that she was pregnant due to conduct on May 20th, 2023, that she was pregnant with respondent's twins through records held by Ravgen, which respondent is requesting this court order be released, and 3, that she is no longer pregnant with medical records confirming the date and week of gestation that the pregnancy terminated. Petitioner simply cannot evade her evidentiary burden, as respondent Clayton is entitled to a resolution as to whether she was pregnant, whether she was pregnant with his twins, and if she was pregnant, what happened to the twin fetuses. I love this angle they're taking. They're saying, we don't believe he was the father, but if he was, I think he has the right to know what happened to his unborn twins. Of course, they don't believe that's the case, but you know, good defense here. This court has subject matter jurisdiction. As such, jurisdiction attaches at date of filing, and subsequent acts by parties does not deprive the court of jurisdiction. This is interesting because this is in response, I believe, to her saying, now that we're no longer pregnant, this isn't a family court, so therefore, I mean, that'd be like saying you could literally, I mean, according to that logic, you could kill your baby and then say, I'm not pregnant anymore, I don't have a baby anymore, so it's no longer your jurisdiction. Oh, if they want to arrest me, they got to go to another court, because over here, just no baby, no foul, you know. And I hate to use such crass sort of thinking here, but again, like issues similar to this have ended in the deaths of people over stolen babies and crazy wild stuff like that. That's has been on the table as something to look out for. Luckily, so far, there's been no evidence of any of that happening. it's all been just wild stories and no actual physical danger, but you just don't know until that happens, right? This court has subject matter jurisdiction. They said subject matter jurisdiction is established at the time of filing of the lawsuit and cannot be ousted by subsequent actions or events. Fry versus Garcia. Always good to have some case law that shows you what you're talking about. Jurisdiction depends upon the state of affairs existing at the time it is invoked, and once having attached is not lost by subsequent events. Ordinarily, a court that has acquired jurisdiction of a case cannot be deprived of jurisdiction by subsequent events in the course of its proceedings, even if those subsequent events would have prevented jurisdiction from attaching it in the first place. Okay, that being a fake pregnancy, right? Well, if it was always a fake pregnancy, whatever, but at the time of the filing, she claimed it was a pregnancy, so they have to continue on with this case, is what they're saying. A presumption exists in favor of retention of jurisdiction, and a divestiture of jurisdiction cannot be inferred but must be clearly and unambiguously found. Well, I didn't think I was going to say divestiture today. Say that 10 times. Say that once, please. That petitioner is allegedly no longer pregnant does not divest the court of jurisdiction. Subject matter jurisdiction attached when petitioner she filed her verified petition to establish on August 1st, 2023, alleging that respondent was the father of her unborn twins. Nothing has occurred that would divest this court of jurisdiction over this matter. There is no statute that explicitly and clearly divests this court of jurisdiction. Jurisdiction cannot be ousted by subsequent events. And 3, Arizona law presumes retention of jurisdiction unless divestiture is clearly and unambiguously found. I mean, I don't know. So it looks like a judge can read this and go, oh yeah, I mean, he's got a point. Like you can't just dismiss the case because the facts have changed. Okay. Rule 9C requirement for Rule 26 sanctions have been met, or if this court determines it has not been met, compliance with Rule 9C would have been futile. All right, so then, more legalese. Arizona Rules of Family Law Procedure requires that parties demonstrate that a party has made a good faith attempt to resolve the issue, and the attempted consultation required by this rule must be in person or by telephone and not merely by letter or email. Here, respondent sent petitioner countless text messages reiterating his position that petitioner's petition to establish was in bad faith, as she could not have been pregnant by him after one encounter of oral sex. Respondent thereafter blocked petitioner's number. She created at least 13 different phone numbers, leading her to send over 500 plus text messages and emails threatening to take respondent to court if he did not speak to her. I'm going to share with you those text messages. It is wild. If you're on the Patreon, you probably saw those last night as we were putting this together. Patreon.com/Dave Neal for breaking news. As respondent had made it clear that he did not want to engage in petitioner, where she granted his injunction against harassment against her. Petitioner, Jane Doe, despite knowing that Clayton vehemently denied she could be pregnant by him, filed a motion to communicate and motion for contempt, denied by this court, to try to force respondent to communicate with her. Put plainly, all of respondent's attempts to resolve this issue by explaining to a harassing and emotionally volatile pro-per, that means she was taking the law in her own hands and not having a lawyer, that she cannot in good faith file a petition to establish as she was not pregnant by him, went unrecognized. So he said, well, I said she was never pregnant. That didn't stop her. She can't let that stop her now. Respondent even offered to meet petitioner in person with a mediator present at public location, which petitioner rejected. We'll show you those text messages. Respondent paid for and engaged in 3 different paternity tests to further disprove this possibility to petitioner in the hopes that medical science would resolve the issue. Nothing would deter her, not even 2 DNA tests showing little to no fetal DNA. The respondent has more than complied with Rule 9C. So here's what Janeth Doeth said. She's in gray, he's in green. She said, it's Janeth. Please check your email. RavGen closes soon. 5 exclamation marks. I want to do the test. 2 exclamation marks. I need you to respond though. 1 exclamation mark. He said, you want to do the test with no stipulations? Would it be better if we played this with the music? And then she said, you're going to be forced by the court to meet up with me, Clayton. You might as well go along with the stipulation since it means 100% I am doing the test. He says, so if we meet up once in a very public setting, like a coffee shop, you will then take the test afterwards. And she says, you are going to be required to do that regardless of whether I take the paternity test now or in February. Then she says, so no, it is with the week's worth of stipulations and hopefully more, but absolutely no requirement in order for me to take it early. Again, it's all for you. I know who the dad is, you. So I'm doing you a favor. Clayton, don't you realize she's doing you a favor by doing all of this? So when she talks about the week's worth of stipulations, my thought is that could be the contract she wanted him to sign, where she says, if you date me with intention, I'll let you do whatever you want with the babies. You can take them to Disney World, you can abort them, you can do whatever the hell you want. That's my guess is what this means here. I could be wrong. So all he wanted to do was meet up at a Starbucks. He had some gift cards he wanted to use. Maybe he was going to pay for her new pistachio latte, which is out now. If you're a lover of a good pistachio latte, go check it out. Either way, another text message from her. I think the app gave me a new number, but it's Janeth. So my guess is she's using an app to get different phone numbers because she keeps getting blocked. I don't know. That's my guess. She said, if you will meet up with me, I will withdraw my request for sanctions. I also don't want to cancel my appointment because you need to be held accountable. All right, let's do this. Let's agree that whoever needs to be held accountable will be held accountable. Let's do that. Okay, sure. Oh boy, that doesn't age well. He said, so you will meet up within the court with a mediator. Mediator sounds like a X-Men character. Come on now, it's Mediator. He just comes in there and his wild unearthly power is to make people get on the same side. It's me, Mediator, and I am here to bond you in the court of law. She said that's not how it works. The whole point of the consultation is to not waste the court's time if the issue can be resolved outside of court, which this can. So we can meet up with just us, and then I will withdraw the request for sanctions. To be fair, she did try not to take me to court. She just wanted me to delete all my videos and never talk about her. Also, she just wanted me to not do what I do, and then she wouldn't take me to court. So I understand. I mean, she gave me a good effort here. Clayton said, sarcasm. Clayton said, would you meet up in a public location like a coffee shop? She said, you want to talk about this in public? He said, yes, in a setting where people and security cameras are, just so that we're both protected. Wow. So sadly, we see Clayton here paranoid, rightfully so, and how sad of that. But this is before he, of course, had the weight of Bachelor Nation supporting him. This is a lonely, paranoid man who thinks no one's going to believe him because he's been looked at as a monster by her. And he knows if they meet in private, it'll be her word versus him. How sad. How sad indeed. Should this court determine that respondent's communications with petitioner are insufficient under Rule 9C, compliance would have been futile, as both parties have restraining orders against one another. Petitioner has an order of protection against respondent and has allegedly attempted to get the police involved in that matter. We will share the police email. The email she wrote, Scottsdale Police. Respondent has an injunction against harassment against petitioner. Although the parties are permitted to communicate regarding ongoing court proceedings, petitioner's commitment to going to the media and harassing respondent made all of respondent's efforts to reason with petitioner futile. Petitioner made it clear that she had no interest in dropping this action despite her knowledge that respondent denied that she could be pregnant by him due to oral sex when she posted, I am the anonymous woman in the Clayton Echard scandal. Here's my story on Reddit and Medium. Reached out directly to the media, The Sun, People Magazine, Page 6. Contacted respondent's father, Clayton's dad. She filed her motion to communicate and motion to compel to force respondent to speak with her. I tell you what, when my baby boy's delivered, not right away, maybe when he's, 15, when I have the birds and the bees talk, I think we might discuss consent, and not just that, taking your time before choosing sexual partners. I think we might just take your time a little bit. Just, go to a Starbucks, meet in public. This episode brought to you by Public Coffee. Petitioner's relentless crusade to accuse respondent of impregnating her, lash out at anyone who disagreed with her, made it impossible for Clayton to try to explain to her that she was not pregnant by him and could not be. Put plainly, respondent could not guarantee his safety around petitioner, which led him to seek an injunction against harassment, which was granted. Therefore, Rule 9C either was met long ago or could not have been reasonably complied with. Respondent is entitled to an evidentiary hearing on his request for Rule 26 sanctions and attorney's fees. Petitioner's conduct is precisely the type of litigiousness and malicious prosecution that Rule 26 seeks to punish, and a separate motion for Rule 26 sanctions is being filed contemporaneously. This is not an abstract question that renders the matters moot, as petitioner claims. Petitioner has been steadfast in her insistence that she is 100% pregnant by respondent, despite offering no verifiable medical evidence as oral sex does not result in pregnancy. That petitioner is suddenly admitting that she is not pregnant only after respondent filed his amendment amended response and notice of non-paternity does not address whether she was pregnant to begin with or whether she was pregnant with respondent's twins. Respondent is entitled to, at minimum, compliance with discovery aimed at determining whether she was pregnant at all, and records from the doctor she testified to being seen by under oath on November 2nd, and an opportunity to be heard for his requested relief and redress for abuse of process and attorney's fees. Situations like these are precisely why Rule 36 requires that, once a respondent is filed, dismissal can only be by agreement or court order. Petitioner cannot unilaterally decide this court no longer has jurisdiction. Respondent is entitled to his reasonable attorney's fees regardless of the source of the fees. Petitioner has acted unreasonably from the very beginning of this actions and continues to act unreasonably in her filings. Respondent has had to obtain community support to defend the allegations from petitioner. That's you guys. Congratulations. Community support. Note, petitioner has a history of fabricating pregnancies and reasons for why she all of a sudden is not pregnant, where another man was accused of getting petitioner pregnant with twins and she claimed she had an abortion as a result. Again, without any medical evidence to support the same. Petitioner's motive to fabricate pregnancies, to coerce relationships, and then to somehow terminate the pregnancy if they capitulate to her demands to date her is disturbing. See respondent's motion for leave to amend for a period of 1 week while determining the best court of action for their pregnancy. Party A and Party B will exclusively explore a relationship. I've offered to give you control over the outcome of the pregnancy if we date exclusively. Petitioner cites no law, as none exists, that makes the source of attorney's fees a defense to the court ordering fees under ARS 25-324. In fact, petitioner admits that respondent has a viable claim to attorney's fees. While petitioner can invent pregnancies, she cannot invent the law. Wow. Guys, here's the deal. We are not nearly as far along in this video as I had hoped for at this point. I have to make a part 2. Stick around. Part 2 will be next.